Hey guys, I love these webinars every 2 weeks because it's the one time I get referenced as an expert. So I do appreciate that. Michael, I see you're still on mute. Can you hear us?
I can hear you.
Our expertise rubs off on you, Craig.
Yes, exactly. Good afternoon, everybody. My name is Craig Vaughan. I'm the Chief Financial Officer of the Castle Group. I'm joined again today by Jeff Rembaum and Michael Bender of K Bender Rembaum, excuse me. I wanted to welcome
best for you saved the best for last in that order. That's fine.
I know. I wanted to welcome you to episode 15, returning to normal. We have lots to talk about today. As a reminder, you're welcome to chat in your questions using the chat feature, and I will try and work those into the conversation this afternoon. I want to welcome back Michael and Jeff. Remind everybody that they are here to provide their general opinion on what we're going to talk about and not give you specific advice for your association. We would encourage you, if you have specific questions relative to your operations, to reach out to your legal counsel directly. Jeff, could you give us a quick introduction to the firm?
Sure, and I'll start by introducing the firm from the bottom to the top, looking at the main screen. Rembaum, K. and Bender. Very nice, Craig. Appreciate the name change this morning. But more seriously, K. Bender Rembaum is a law firm specializing in representation of Florida's community associations. Numbering somewhere north of 1,400 so far. We're 20 lawyers. 9 of us are board certified experts in the field. We have offices in Broward County, Palm Beach County, Hillsborough County, and thanks to Michael, in Miami-Dade County as well. I publish Rembaum's Association Roundup, where you can find the community association news that you can use dealing with new legislation and new court cases of interest. My partner, Robert Kay, hosts a monthly call-in radio show where you can get your questions answered. We encourage all of you to call in and really give him a hard time this month. It's from 6 to 7 p.m. We'll send out some email flyers on that as well. My partner, Peter Mullengarden, co-hosts a weekly radio show called Condo Solutions every Monday from 9 to 10 a.m. And again, you can call in there and get your questions answered. We hold a whole host of different webinars during the week. My partner, Michael, is extremely active, and most especially this year with CAI and its Legislative Alliance. And Michael can address that more as we go on this morning. But that's a short story of who we are and what we're all about, Craig.
Thanks, Jeff. Michael, quick introduction of yourself.
Just good afternoon, everybody. Nice to see everyone. And I'll only point out with a smile that even reverse, Jeff, it would be Bender in the middle. So it'd be Rembaum, Bender, K. You're not going to, you don't flip it around.
That's fine. We could go Bender, Rembaum, K too. I'm easy.
KBR just works.
It does. I agree. We'll keep it that way.
Good, guys.
Good to see everybody. Thank you for joining us, Craig. Let's get the show rolling.
Welcome back. We are going to use polling, the polling feature in Zoom again today. So I would like to start with the first question. It's an easy one to get you used to doing work as participants in the webinar. What type of community do you live in? While we get our participants to answer that question, guys, our main topic today is returning to normal. But there's several topics we're going to cover. First, a look on the emergency order and where we are, the results of the recently ended legislative session. I think the meat of the discussion today will be on a review of the announcement by the Surgeon General of the state of Florida and the latest executive order by the governor regarding COVID restrictions. And then we're going to have some quick hits on relaxing the rules that to see, are we returning to normal? What is everybody else doing, which is something that our participants have told us they like to see. So before we jump into the emergency order, Nez, can you post the results of who we're talking to today? So interestingly, guys, it's about half and half. Actually, a little bit more condo and co-op than HOA and than HOAs. We do have, though, 45, 55 and better communities, as we say over here at Castle, that are on the call today. So that's great news. Thank you very much. So good split. Let's jump into the emergency order. Last month, we were waiting on whether or not the governor would extend the state of emergency declaration. He did. It's now set to expire on June the 26th after being extended. There is some confusion, guys, that I think we want to address today, and that is the state of emergency. For clarity purposes, the state of emergency is still in effect, notwithstanding the governor's recent declaration or recent announcement to suspend all COVID-19 restrictions and mandates. So the emergency order is still in place. However, the governor has, in his latest executive order, suspended all COVID-19 restrictions and mandates. Two things we're going to talk about today. Do I have this right, Jeff? Am I reading that properly?
Conceptually, you do. The boards still have their emergency powers in play because the state is still in a state of emergency. What the governor did in Executive Order 21-102, for those of you that like to look these things up, that was 21-102. He put out an order that supersedes and eliminates local government orders that required restrictions and mandates on individuals and businesses as related to COVID-19. That is what the governor did, not to be confused, and I know we're going to talk about it in a few minutes, with what the Florida Surgeon General did, which is something totally different. So for purposes of this conversation, emergency order still in play, emergency powers still in play, with a caveat that if the legislation gets signed, we're going to have to talk about the changes, maybe next month after, to those powers. But so we have the governor, and all he said was, local governments, you can't pass any orders requiring people to do things in regard to COVID-19 anymore. That power is with me in Tallahassee. So that's what 21-102 does. It puts mandates on individuals and businesses. It does not, it doesn't put mandates on them. It says local government cannot put mandates on them. And we'll conclude that with, this has no effect on our community associations. Community associations, you are still free to do what you think is best for your community using the emergency powers or normal regulatory powers, police powers that you have, health, safety, and welfare.
Okay, Jeff, that's great, and we're going to talk more about that later on in the show today, or the webinar today. So a little fun here. Last time we met was just before the emergency declaration was extended. Nez, can you post poll question number 2? So right now, I would like to see, just generally, do you think the emergency declaration will finally end on June 26th? While you answer that question, I will remind you that last time we asked this question before the last renewal, 63% of us suggested that we were was not going to be renewed. So of course, just pointing out again that we're not perfect, which I know our vocal minority residents already know. So Michael, to you, do you think it's over on the 26th?
I'd be remiss if I didn't point out I was part of the 37% though, because obviously it was maybe more hopeful than definitive, but because of the numbers, honestly, this time I've been fairly confident that he would extend it every time before. I don't know. The numbers have been low. I just heard yesterday, which I was pleasantly surprised to hear, that the positive percentages have been between 3 and 5%. I don't know how long that's been. There is the question of the variance. I mean, we're not out of the woods, and I think the thing is, he's done a lot of with his order that Jeff just very well explained. I'm hoping he extends it one more time for 2 more months, because he's got these orders in place and just allows things to sort of wind down more efficiently. In my opinion, I think he's kind of jumped ahead quickly. Some of it's been successful, and hopefully all of it remains successful. So I'm hopeful he will. I think though, I'm leaning toward thinking he won't.
Nez, let's post the results, because I think what it's showing is the same people who voted no last time are voting no this time, save and except for Michael Bender, who's now changed his mind.
I've moved to the no camp, unfortunately.
So it looks like 70%, 69% are suggesting that we will be through the emergency declaration at the end of June, which causes a whole bunch of issues, which we will deal with. Several issues that we'll address at the next.
I think questions more than issues. I think Craig had questions.
All I know is my outline says I'm going to be asked that question.
I hope I'm wrong.
I was going to say, Jeff, what do you think?
There you go. I think if it's tied to money, I think if the state of Florida, by the governor's issuance of a state of emergency, entitles us to federal funds of some type, if there's a kind of economic advantage, then I think we stay in the state of emergency.
Smart.
If no more money at issue, the feds aren't giving out the money, then I don't think we're going to be in a state of emergency.
That's a fair comment. Good stuff. Okay, well,
that's a very good comment. Yeah, unfortunately, that's green controls. You're right.
Yeah. Well, we'll revisit that in a month or so. Okay, let's go on, guys. But it does appear with that everybody believes, as do I, that we are counting down to some type of return to normalcy. So that, that is
Fingers crossed.
thank goodness. Yeah, that is the gist of today's discussion. Before we get into the meat of that, the legislative session recently ended. Bunch of bills were approved. We reviewed a bunch of various bills last webinar, so we won't review them all again today. But there are a couple of high-profile bills to touch on. The COVID liability bill. Jeff, can you quickly summarize for us what that's all about?
Sure, absolutely. And again, for the history buffs out there, we're talking about Senate Bill 72, if you want to look it up. This is already law. It was effective on March 29th, 2021. In short, if a plaintiff, right, someone who alleges damage against a business, against a community association, pertaining to COVID-19, I got COVID-19 and got sick because of you. Then we have this bill that helps protect our associations, that so long as the association made a good faith effort to follow federal, state, local guidelines, then there's a good chance early in the case it will be dismissed. The plaintiff in the case has to show that the defendant, i.e. the association, acted not just negligently, but acted with gross negligence and intentional conduct. And they have to prove it by clear and convincing evidence in order to establish that liability. So it's a very high standard, and it's a 1-year statute of limitation from the time the plaintiff knew or should have known they had a potential case. So this legislation makes it nearly impossible, I think, for a business to be held liable for someone getting COVID-19. And I think it helps society reopen because now different types of venues don't have to be in as much fear they'll get sued for putting people together.
Okay, good. I appreciate that. And we're going to, again, touch on that a little bit again later when we have a specific example of what an association's done and whether or not it makes sense. And then, Michael,
Yes.
Can you tell us where we landed on rentals? I know that's always a hot topic.
Sure. There no change in the rental language in condominium or cooperatives, but Chapter 720, which is the Homeowner Association Act, has a potential and very likely significant piece of legislation. It's Senate Bill 630. Senate Bill 630 has passed, waiting to go to the governor, and it's fully expected that he'll sign it. And quite frankly, there's a lot of good legislation. It's 103 pages, so there's a lot of good stuff in there. And so signing it, I think, will be a good thing. The one piece about rentals with the HOA Act is, if the bill passes, it takes effect July 1st, 2021. So as of July 1st, 2021, in a homeowner association, you will be if the community tries to prohibit or regulate rentals by amendment, it will apply only to the parcel owner who consents to the amendment, affirmatively consents to it, or to a parcel owner that takes title after the effective date of the amendment. So that's the law with rentals in condos. The change we were able to address in HOAs, and when I say we, I said as Jeff mentioned, I am on the Florida Legislative Alliance, and we have a lot of good things in this bill. This we didn't love. It was going to pass anyway because it was a pet project of a House leader. So we did get them to agree to water it down a bit. Any amendment that prohibits or regulates rentals of less than 6 months or prohibits rentals more than 3 times in a calendar year is exempted from that, meaning that type of amendment will apply to all residents, whether or not they consented to it. So what this means in summary is, after July 1st, 2021, HOA communities can still do short-term rental restrictions, and it will apply to everyone, whether they vote for it or not. But if you're looking to do long-term rental restrictions after July 1st, you need to administratively document who voted for it and who voted against it. There's also language in there that clarifies what, quote, change of ownership means. It's not your simple. So if I own the property and I've been leasing it and I don't vote in favor of that amendment, and then I I gift it to my son, that won't be considered a change of ownership. So my son would have the same exemption that I had on that long-term rental. Once this does get passed, you'll want to obviously communicate with your legal counsel. We will be putting more information out about it, as well as a firm. But that's a big one on rentals for HOAs. So by the way, as an HOA, if you're looking to limit renting and you want to limit long-term renting, you want to do that now. Get with your attorney, get a draft, get it out to the membership, get them to approve it, and get it recorded by June 30th so that it impacts everybody. And this law will not take effect till July 1st.
And since you need a 14-day meeting notice to take that vote, like Michael said, you have just enough time if you call the attorney this week, next week, to get this done for you.
Excellent.
Right.
So guys, the legislative session closed. There's a bunch of bills. We've heard about a couple of them. What happens now with everything else? Michael, do you?
Yeah, the way it works up until so the bill, there's a couple of hundred bills that probably passed. There's about a half a dozen or more, maybe closer to a dozen bills that touch on community association, impact our industry, some substantially, some just small pieces. The governor essentially and the governor's staff tells the legislative staff, who has the House leadership, Senate leadership, they're ready for bills to be sent over. These bills are sent to the governor in batches because the governor has 15 days from when he receives a bill to decide whether he's going to sign it or veto it. If he does not sign it or veto it, it becomes law automatically. But the reason, so that's why they can't send him 200 bills and say, go ahead, take care of these, because he only has a 15-day window in which to review it. So they send them over in batches, and there is, and my understanding is there's no rhyme or reason. It's not like he'll say, okay, send me over community association bills next. They will send bills over with effective dates of, some bills are July 1st, others are October 1st. So they'll send the bills that have an effective date of July 1st over, and they'll start doing that, or they might have already started doing that over the next few weeks. And so between now and what's May 12th, between now and the next 30 days, bills will go over in batches that are effective July 1st for the governor to review and either sign or veto. And that's how so that's where we're at now. We're waiting for the governor to get the bills and then either sign them or veto them.
And on top of that, I want to add a little bit as well, that at the moment, I've put an outline together with about 75% of what we expect the legislation, the governor to put into law. We're at 19 pages so far. So we have a lot to talk about. I'm talking to the viewers that are out there. If all these bills do become law, there are some tremendous changes coming that each and every one of you are going to need to be aware of, far more so than what we're getting into now. But it is extensive. I think this year is definitely an omnibus type year where we just have legislation after legislation after legislation affecting community associations that you'll need to be aware of.
So I would recommend you sign up for a K. Bender Rembaum legal
update
when they come out. But great, guys. I appreciate that. Let's move on to some of the confusion created this week. So for the first time we heard, and I didn't even know Florida had a Surgeon General. Last week, he came out with a public advisory relative to COVID. So I'm going to read it to you because I think it's, first of all, I could never make it up myself, but I'll read it to you and then we can discuss it. So from the Surgeon General, the Florida Surgeon General, due to COVID-19 widespread vaccine availability, fully vaccinated individuals, and I highlight that, should no longer be advised to wear face coverings or avoid social and recreational gatherings except in limited circumstances. Should no longer be advised to wear face coverings. So here's what happened.
Wait, Craig, I'm sorry, don't highlight that without pointing out that without except in limited circumstances.
Oh, that's my point. And that what our boards read was we don't have to wear masks inside anymore. And it is very specific to if everybody is fully vaccinated. And I want to couple that. Let me finish, Jeff. I want to couple that with what the governor's executive order proclaiming that all COVID-19 restrictions and mandates on individuals and businesses are hereby suspended. So what we have out there, guys, is some confusion, right? Do I have to have masks? And I think the question is, to your point, it's fully vaccinated individuals. It's not everybody. Doesn't have to wear a mask. And then really what our associations want to know is, can we still require masks in the clubhouse, in the common areas, and around the pool? Are we within our rights? So, Michael, your thoughts?
Well, okay. Well, the first thought is absolutely, as a board, you still have the authority to require facial coverings in areas that you as a board believe would best help protect the health, safety, welfare of the community. Inside versus outside, I think, is the biggest distinction. This advisory from the Florida Surgeon General, and like Craig, like I said, and like you, I said, I mean, where's he been? I mean, we haven't heard word one from this guy in over a year plus. And I said, it says they should no longer be advised. I just think that's a very poor way of putting it. And except in limited circumstances gives no guidance on what that actually means. But I do think inside and outside are very different scenarios. So you need to communicate with your management team, you need to communicate with your lawyer, and you need to get clear guidance on the do's and don'ts. But to reiterate, this does not impact the authority of a board to properly adopt rules and regulations in accordance with your governing documents. That requires social distancing, that requires facial coverings, certainly inside areas. Around the pool, you can, whether that's considered reasonable under circumstances is something you have to, there's some factors involved. Even the CDC listed certain factors. What is the nature of your community? Do you have COVID issues right now? Do you have a group that is highly impacted and isn't vaccinated? So there are a lot of factors involved. It's not this it's like almost like you get a headline and you don't in an article and nobody reads what it really says, and that's dangerous.
Yeah, I've been guilty of that, actually.
Actually, the Florida Surgeon General has been busier than either both of you or myself were aware. And once you get into the logic of why he wrote what he wrote, it does make better sense. So let's talk about that for a second. Because what he did was he put out 4 orders over the past year, all right, from the Florida Surgeon General that dealt with face covering requirements, that dealt with proof of residency in order to get a vaccine, that dealt with what to do in gatherings of 10 or more, what to do if you're high risk and over 65. He was advising stay home, avoid contact, and the list goes on. So he had those orders out there. Then the governor comes out, and the governor comes out pretty strong, and he says to the local governments, hey people, you no longer have the ability to create COVID-19 type restrictions on individuals and businesses. But we have these orders from the Florida Surgeon General doing something very similar to that. So what the Florida Surgeon General said was, due to, as Craig, you said, but now it makes more sense in context, due to the COVID-19 widespread availability, fully vaccinated individuals should no longer be advised to wear face coverings. And that's what he had done in his previous writings. The Florida Surgeon General was advising people to do that. So he was just taking back his own advice in this latest order that caused all that confusion. Now, if that doesn't confuse you enough, in a few minutes, Craig, when we get into the CDC talk about what is presently suggested and required, we're really going to dig into the nitty gritty on that in just a few minutes.
Well, let's jump into that because we're familiar with a community not managed by Castle, not represented by KBR. I will state those as conditions that recently announced they were going right back to normal. So no masks indoors or out, moving all equipment back in the gym, no scheduling of use, full capacity at the pool, card rooms and programming back in place. And before I ask for your comments, I do want to post poll question number 3, Nez. Has your community returned to normal, eliminating the special COVID-19 rules for wearing masks and social distancing? So let's see how aggressive people are being. And then given that set of circumstances, Michael, I want to ask you, have they gone too far too fast?
I mean, it's a personal opinion, obviously.
Yeah.
In my personal opinion, to drop all restrictions, including indoor, outdoor, seems a little too fast.
And Jeff, do you think they have any exposure under the COVID-19 bill limiting liability? Like, are they?
Well, sure. I mean, exactly that. They have, this association had the opportunity to hide behind the governor's latest order, if you will, not an order, but law now, right? That provides protection in the event of a COVID-19 claim. This association that you're describing really has nothing to rely on to show that they acted properly under those circumstances. Could it be argued that they used a good faith effort to follow federal, state, and local health guidelines? There are still federal guidelines out there that we're about to talk about under the CDC. This association basically has voluntarily given up the protection set out in Senate Bill 72. They don't have it.
Right. Interesting.
So I think they're flying blind at the moment. I understand the desire. I just think they should have been a little smarter and probably still had certain requirements, most especially indoor requirements.
Well, and we're gonna get into indoor and outdoor because I think you both made that distinction, which I think is a valid one. In that they're different conditions, right? We've now learned lots about the ability to, or the likelihood of you getting the virus. But let's show the results, Ness, of the poll. It's interesting. 90%, 89%, 225 associations have not returned to normal, but 30 have, so 10% have. So that's a little higher than what I've seen. That's not consistent with our clients, but nevertheless, that is what our listeners are telling us. So
Right. Well, and
you're
to
not
your
alone.
point, Craig, to your point, I think I was surprised to see 29. I'm happy to see it's only 29, but still surprised. And I'm hoping that none of those 29 are clients of this firm. And if they are, they haven't communicated with us about that.
Right. Fair enough.
Well said.
Okay. Well, that's good stuff. So guys, one of the things we're asked a lot, and we're gonna by our webinar participants, is what is everybody else doing? Because they don't have a great forum for figuring out what everybody else is doing. So we're gonna run through some quick hits relative to what people are doing with respect to their amenities. So strap on your seatbelts and let's post some questions. So first, let's see if the associations are relaxing their rules, generally relaxing the rules. So Nez, can you please post poll question number 4? With the rollout of vaccines in the last month and the recent executive order suspending all COVID-19 restrictions, has your community made any changes to your amenity use restrictions? So while they're answering that question, Michael, what do you think we're going to see here?
Well, I think that, the last question shows that you're going to have at least 29 communities who have decreased use restrictions. And I think this is hammering down more. I believe many more communities, if not most, I know it's not all, but if not most, have relaxed restrictions regarding use of pool, maybe tennis courts, pickleball courts, outdoor activities, which to me is logical. From all the information and the science and parsing through some of the confusion even we're getting from the CDC, I think that makes sense. But continuing to do cleaning, maybe not deep cleaning, but certainly continuing to cleaning. So I would expect we're going to see that the percentage of people who've decreased is going to be up, but it's going to be because what we didn't nail down there is decreased indoor outdoor difference. I think it's going to be
about that. We are going to talk about that in a second. So generally, so before we get to the results, Jeff, I know you advocate for associations to, regardless, continue to follow the CDC guidelines at this point in time. Can you just remind us of what those guidelines are?
Are you sure you're ready for this?
No, never ready for your dissertation.
Okay, buckle up, everybody. Here we go. We're going to start talking about the CDC guidelines as they exist today. This is subject to change by tonight, knowing the CDC. Things are changing.
After they hear this webinar, they might change it.
They might. We're going to talk first about the, in general, CDC requirements. Then we're going to talk about how they apply to people that are fully vaccinated. Then we're going to also break down indoor and outdoor social distance limitations and cleaning and disinfecting. So in about an hour, we should be through with this conversation. In general, CDC provides masks should be worn as follows. People that are 2 years of age or older, anytime in a public setting, anytime on a plane, bus, train, or other form of transportation. Most importantly, when you are around people who do not live with you, including inside your home or in someone else's home. Inside your home, if someone you live with is sick with symptoms of COVID-19 or has tested positive, you want to wear the mask. However, they also provide guidance which makes the masks not necessarily necessary when an individual is outside by themselves and away from others, or when an individual is with people who lives in their own household. However, again, if there's others around you that do not live in your household, then the CDC wants you to wear a mask. Now, we have some different restrictions for fully vaccinated. These restrictions I just spoke about were in general, and it really didn't talk about vaccinated. And when we talk about vaccinated individuals, we're talking about 2 weeks after your last dose, if you had the 2-dose series, or if you had the 1 dose, again, 2 weeks after that. So different restrictions for fully vaccinated people. You can visit with fully vaccinated people indoors without wearing masks or physical distancing. So if everybody is vaccinated, CDC says you don't need to worry about the mask or physical distancing. You can visit with unvaccinated people in a single household who are at low risk for COVID-19 without wearing a mask. and you can participate in outdoor activities and recreation without a mask, except if you're in a crowd or some type of venue. I want you to think going to the fair and a concert. Let's go back and read one of those again. You can visit with unvaccinated people in a single household who are low risk for COVID-19 indoors without the need for the mask. However, CDC still recommends that fully vaccinated people wear masks when in indoor public spaces and when engaging in indoor social activities, because the vaccination status of other people is likely unknown. So in public indoor places, everybody should still wear a mask. But when you're outdoor, fully vaccinated people do not need to wear masks. And masks may not be necessary for unvaccinated people outdoors if they're by themselves or only with people who live in their household. All right, so far, so good. That's about half.
That was easy, yeah.
Oh yeah. Cleaning and disinfecting is really easy. The guidance provides that so long as there are no people confirmed or suspected with cases of COVID-19, then cleaning once a day is generally sufficient to remove virus that may be on surfaces and help maintain a healthy facility. So when we talk about enhanced cleaning protocol, even once a day by the CDC, so long as you don't have a COVID-19 outbreak, seems to be okay and a good way to go. When it comes to social distance and limiting on gatherings, CDC makes clear that masks are not a substitute for social distancing. CDC recommends that masks be worn in addition to staying at least 6 feet apart, especially when indoors around people who do not live in your household. Still recommending avoiding large events and gatherings. And the CDC does not recommend large gatherings for the unvaccinated folks. So that's sort of the gist there. So that was quite a mouthful of information. So let's tie it all back together again to Senate Bill 17, or Senate Bill 72 rather, where the association, to get the legislative protection from liability, you have to make a good faith effort to follow federal, state, local guidelines. So how is that association that chose to fully reopen, have no requirements, leave it up to the people? Because you don't know that everybody is vaccinated. You don't want to become and ask people that either. So I do think if they're outside, it makes sense to release those restrictions. But I think indoors, for the time being, it would make sense, I think, to keep the mask mandate in place, and an association is well within its rights to do so, with or without, by the way. Mike, you and I haven't talked about this yet, but it's quite possible, just using the police powers of an association, which you always have health, safety, welfare powers, there could be reasoning to have a mask rule in place even after the emergency order ends.
Sure.
And talk more about that as time goes by. So,
So
and if you're lucky enough to be a client of our firm, I'm going to share all this information with our attorneys. So by the end of the day today, your attorney, whoever you deal with, should have all this information at their fingertips. You can give them a call so that they can put something together for you in terms of reopening plans. So you can actually, because you really have to read this several times to digest it.
So so just to kind of summarize, if I can, one, the CDC still, let's do it inside first. The CDC is still recommending masks and social distancing.
Well, if everyone's vaccinated, though,
yeah, but
all of a sudden the mask isn't required, but we don't know that in our community associations.
Yeah. So it's reasonable to follow the CDC guidelines, which are masked inside, social distance, talk about outside last after, and then you're well within your powers under the emergency declaration to maintain those restrictions if you have them. Is that
absolutely? Is
that a summary? So, and we know boards, we know you're getting questions from the resident who says we don't have to do this anymore. But those are your answers with respect to why, and we're going to share in a second what your other communities are doing, so you can point to the results of our survey to see where you are. But
Craig, can I just add one small point also, if I can? Just because issues, the question, I know the CDC talks about, and Jeff, that was great, by the way, and I do want to see it in writing and digest it better, but vaccinated versus unvaccinated, and and I saw questions posted, and we've also talked about this. You're not inquiring, you're not making people wear like a bracelet that says vaccinated. None of that's going on. And so how do you address this? Well, in my opinion, you have to address this indoors in particular, as if it doesn't matter. Facial coverings indoors and not necessarily outdoors. And I'm talking about, when you're talking about the use of the common amenities. I saw someone else posted up there too. I mean, if we're talking Broward County, for example, and I think Miami-Dade actually has done best as far as vaccinations as of last night. 60%. Broward County's at 56. I don't know where. I think Palm Beach was about 50, 52. I don't know if I saw that right. But obviously those are going up. And once we see the herd immunity, quote unquote, then maybe that's even more of a reason to start loosening indoors. But I think it's been very well stated that when you're indoors, you don't, that you should be wearing them and not focus your rules on vaccinating versus not vaccinated.
That's a good point. Okay, so let's Marinez, let's post the poll question number 4 are you increasing, decreasing your restrictions? And last time we asked this question a month ago, we had 23% of people who had decreased use restrictions. We're now at, look at that, guys, almost half, right? Have decreased their restrictions. I would guess the increases are because relevant to a specific incident in the community would be my guess. But half and half. So people are starting to decrease use restrictions and again, return back to some level of normalcy. So any comments before I jump on to some specifics? Let's jump into specifics because I think this will separate kind of the indoor and outdoor. So let's find out where we are relative to pools, gyms, and clubhouses, just as a quick overview. So Nez, can you post poll question number 5, please? Where are you with respect to the opening of your gym, pool, and clubhouse? And just so that you guys have some comparative data and we have some context, last time we did this a month ago, 94% of pools were open. So almost all pools are open. 53% of gyms and 36% of clubhouses. So we'll give that a second to get people's results. But okay, Nez, we're almost done. I think that you guys are not going to be surprised. So let's close that off now, Nez, and can you post the results? So guys, almost all pools, right? For all intent and purposes, 96% of pools are open. Gyms, 62%, so that's up significantly. And then clubhouses, 43%. I will remind you that is, actually it's about 50% of those people who have clubhouses. And by the way, 75, 80% of those people who have gyms, if you really read through the results. So we're really starting to see the amenities come back into use from our clients. Any comments, guys?
I think it's great. I think as long as, like, in particular with the gym and the clubhouse, I think they should be open, but I do think they should be open again, wearing, so, that should be facial coverings, inside, or even some sort of limitation on how they're using it, unit appointments and things of that nature. But absolutely, I think the amenities should be able to be open, in more, because we know a lot more about how this thing is working. And hopefully, you don't have to do the deep cleaning, but you should still be sanitizing. And I think, to Jeff's point earlier, as you're opening these facilities up, in order to ensure that this COVID liability protection is in place for you, make sure you're documenting your safety, what you're doing to try to stay safe. CDC are guidelines, they're not mandates, but they should be followed to best protect. And as we've mentioned multiple times, and I always say it, speak to your insurance agent, make sure you're doing whatever it is you need to do, signage or otherwise, for your carrier's requirements, so that you have that in place should a claim come up.
Yeah, we're advocating the same, which is, follow the CDC guidelines. They're there, they're good, they're defensible, and obviously they're affording you some protection. Guys, let's jump into now the specific indoor and outdoor change. So Nez, can you post question number 6? So with respect to your pool, 4 questions. Are you restricting capacity or utilization? Are you still requiring masks and social distancing outside at your pool? A new one, are you allowing guests and visitors to use your pool? And then, are you maintaining enhanced cleaning protocols? So, Michael, you gave us some guidelines. Jeff, I appreciate your comments on, your clients are calling you, we're loosening restrictions. Are you just advocating what you said, which is follow CDC guidelines, be careful, notify your attorney? Is there anything else we should know? Maybe document?
Documenting was good, brought up by Michael just a moment ago. So
And
that,
insurance.
yeah, sure. If anyone accuses you, you get that letter from the PI lawyer, save all your information because, Joe was susceptible and because of your negligence, he got sick, got COVID, and God forbid died. And now the family's coming after you because let's not kid ourselves. The association is the deep pocket and so is the management company.
Right.
So the PI lawyers won't miss it. And if you're not in a position to show that you made that good faith effort to follow those guidelines, then where's your defense? How are you going to hide behind that legislation to say nanny, nanny, boo, boo, right?
Right.
To that association that's fully relaxed, would it be possible to argue that in their doing so, they acted with gross negligence and intentional conduct in light of the circumstances that they were facing? Was it gross negligence? Was it, remember, gross negligence is not just acting dumb, it's acting really, really, really dumb. Could it be argued that association made a decision that was really, really, really dumb by completely removing all restrictions? And I think the answer to that is when you go to the indoor setting and they remove the restrictions there, when everybody is still saying, if you don't know if people are vaccinated, continue to wear the mask. And that's coming out of the CDC. I know the state has rescinded it, but it's not what people think. The Florida Surgeon General didn't say, don't do it. He simply said, I made recommendations in the past and I'm withdrawing my recommendations.
Right.
Very different circumstance.
And I mean, I thank you again for reiterating that, Jeff. I just think that is so important, in this advisory. And it was a whereas clause that he said this.
Recital not even incorporated into the body of his own order.
Right. It's technically not. It's a whereas, I've advised, that and the limited circumstances are sometimes unknown. The obvious ones are when you're in, large social gatherings, concerts and sporting events or big gather. But some of the other circumstances are exactly what Jeff just said. You're inside your clubhouse and you have a bunch of people, 10 tables, everybody's playing cards, and maybe maybe there's a half a dozen people who aren't vaccinated. And one of them happens to be a little sick, you don't know. It just, I think that, it raises questions because the COVID liability bill does say, that you make a good faith effort to substantially comply with these authorities governing. And that's one of the unfortunate parts of the order from Governor DeSantis. And what it does now is it throws things into question. And in my opinion, I think that basically what Jeff is saying is you'd rather be on the safe side of that and not have to be arguing in court. Well, there are the governor said no restrictions. So we just said no restrictions. And so our good faith effort is there. I just don't think that's
misnomer. People think the governor said no restrictions, and he didn't. He said to local governments, you can't put restrictions on people or on businesses related to COVID-19. But he never said there can't be restrictions.
Right.
Let's look, guys.
Themselves
That's true because businesses can restrict. All your Publixes, Winn-Dixies, etc., and community associations can and probably should continue to restrict indoors at a minimum.
We're doing outside for pools. So I think kind of as expected, can you post the results of the poll question number 6, Marinez? So let's go through these. With respect to your pool, are you limiting capacity utilization? About half and half. With respect to your pool, are you still requiring mask social distancing? So 40% yes, 56% no. So there was a question from webinar participants. Do you have to still require mask and social distancing outside? It sounds like the CDC guidelines are you don't have to outside, Jeff. I think that's what you just read us. And
again, it says that though, I believe if you're with family people outside of your household.
Correct. Sorry, yes, that's correct. So if you're
and not able to social distance, then you should still wear a mask.
But it looks like again, 40% are still requiring, but a lot of communities have let up just their mask and social distancing rules outside. Are you maintaining enhanced cleaning protocols? Most are still. 58% are, 39% aren't. So that's probably good. Jeff, there's no particular product with respect to enhanced cleaning. It's more a schedule. Is there anything with respect to product?
No, not that I saw anyway in this latest research.
Okay.
But I would say to the associations regarding there's no harm to leaving some of that signage up. You don't have to play the role of the police and enforce outside, if you will, like you might inside. If you have an inside rule, wear your mask, and someone isn't wearing it, maybe we're going to show them the door. But outside, we can still recommend to people to make smart choices.
Mm-hmm, mm-hmm.
And I think that's where the signage comes in and communicating with your insurance company to find out what they want to see.
Yeah. And then with respect to your pool, are you allowing guests and visitors? So 61% are saying yes now and 37% no. So again, I think, guys, is a consistent theme here, right? It's starting to come back a little bit, which I think is what we would have all expected. So, well, that's great. That's great data from our webinar participants.
Yeah.
Thank you very much.
Yes.
Let's move on to question number 7 with respect to your gym. So we'll change from outdoor to indoor and see what that looks like. So same real questions with respect to gyms. We didn't address guests in gyms because it's a little less relevant, but please, with respect to your gym, 1, are you restricting capacity, utilization? Are you still requiring masks and social distancing? And are you maintaining enhanced cleaning protocols? There was a question from one of our participants regarding if you're not monitoring, how do you know you have enhanced cleaning? And I think, that becomes, are you contracted to do it? Do you have a schedule? Like, are there ways to document it without someone watching over the housekeeper cleaning the pool area? Would you guys agree?
Seems logical.
Okay, so let's see, with respect to gyms, I think what we're going to see is kind of the same trend, but not maybe as drastic. So Marinez, will you show those poll results, please? Okay, with respect to your gym, are you limiting capacity utilization? 60% are. Actually, even more than that, guys, because there's really a whole bunch of NAs. So most are still limiting capacity utilization of the gym. What's that? 26 over 150. So 12%, 15% aren't. Are you still requiring masks and social distancing in your gym? 3/4 are. 117 of 153. So 3/4 are still requiring masks and social distancing in the gym. And then last one, with respect to the gym, are you maintaining enhanced cleaning protocols? And again, 75% are. So I think, Jeff, they're following your guidance inside. They're wearing masks or social distancing. We're limiting utilization, and we're cleaning on an enhanced level. So great news for all of great information for everybody. Guys, any comments? Because I have a walk on here I want to throw out for you. As we move through this stuff, we've kind of concluded our discussion on the cleaning protocols. Any closing comments on the returning to normal and the use of amenities before we jump into the last topic?
Just to make good, smart, well-reasoned choices.
Yeah, I think I would say.
And reach out to your experts.
Reach out to your experts. And you know what? I would say from a board, there is the vocal minority always. They're loud. And they're going to advocate for exactly what you don't, exactly the opposite of what you advocate for. So I would say, stand your ground. You're in good spot from a liability standpoint. We get to the end sooner if we all follow the rules right now. So last topic is one that we get often asked relative to collections. And we have said throughout our webinar series, maintain your current protocol with respect to collections. People owe the money. Notwithstanding the fact that you may or may not have your amenities open and maybe your costs have changed, but there is some new legislation relative to collections. We talked about it a little bit before. Guys, maybe Michael, can you give us a quick outline of what the new rules are with respect to collecting delinquent and maintenance if the bill is approved?
You're talking about the Senate Bill 56.
Yeah, I think so.
And yes, if it is signed by the governor, and if my fingers are crossed, it's not. Yeah. There will be there'll be a new requirement, essentially, that there'll be a 30-day courtesy late notice will need to be sent to all delinquent owners before you can refer the matter to legal counsel and have that owner incur any attorney's fees. I think we all agree. I think for the most part, and I know everybody at Castle, and I know pretty much the communities we work with, courtesy late notices go out anyway. So this seems to be, giving a solution to where there is no problem. But it's going to add a 30-day. The most important part of this, though, is that 30-day late notice will have there's a form that will be that's in the proposed bill that you need to, quote unquote, substantially comply with. And speaking for myself, my concern, which I have raised all along, and I will say here, is what I believe that does is that adds a layer of procedures that now give the individual, and not the person who's late once in a while and oops, something happened, they're going to make good. It's those habitual people who are habitually late or who look to avoid having to pay at all and impacting the rest of us who have to then pick up the missing assessments. It's an extra layer of procedure that, if not properly followed, gives that individual an opportunity to either further delay. Let's say a file comes over to our office and that first letter hasn't been done properly. We have to kick it back. And now a new 30-day letter has to go out, giving them a whole nother month to delay paying. If and for some reason it gets through, I won't say our office because I'm telling you it's not going to get through here. But if there's another place where it gets through, it goes up and it goes to foreclosure, and they argue at the foreclosure. They get a lawyer, and there will be lawyers who take these cases. Just these cases will argue, hey, the notice of intent, the notice to foreclose, all that's done right, but that first little courtesy notice didn't comply with the statute substantially. And if the judge in that instance agrees, they kick that whole case and they have to start all over. They've lost all that time. Plus, there's all these attorney's fees that are incurred by the association paying the owner's attorney as well as their own association fees. I said this earlier, and I'll say it again. It was the issue that came up was a tiny flea. Somebody, the host, the proponent of the bill, who is the Senate president, in my understanding, was emailed a late notice instead of being mailed a late notice, and they had been mailed in the past. So he didn't get notified. He didn't see his email. He got a late note. He got a notice from the attorney with attorney's fees, and so he was frustrated. And I understand the frustration. And so he created a bill which requires that if you're going to change the way you send a late notice from mail to email or email to mail, you first have to get acknowledgement from the individual. Okay, I can tolerate that. That's addressing the problem. This additional requirement is overkill. And that's where I'm hoping that it's seen that way and it doesn't get through. But if it does, you need to know, all you managers, self-managed boards, that this is going to be a form requirement that you need to do properly before you can refer a matter for collections.
Jeff, any?
I wanted to just add a couple of things. I was reading through some notes on the legislation as well. There's a rebuttable presumption that the association mailed the notice in accordance with the new law if a board member, officer, agent of the association, or the manager, licensed manager, can't just be a manager, it's got to be a licensed manager, provides a sworn affidavit attesting to the mailing. So now there's going to be yet another step for the folks involved in the process in order for the association to be able to protect itself. So when the owner says, I didn't get the 30-day letter, the association is going to need this affidavit in its file in order to prove to the court that, in fact, they followed this new required statutory format. In addition, once you send that letter, additional collection action cannot be taken for 30 days from the date of the letter. So.
And if it does pass, by the way, your condominium notices, statutory notices, the notice of intent to lien, notice of intent to foreclose, will move from 30-day notices to 45-day notices, which is what it is in the HOA Act. But in the condo setting, and I don't know why they were different, but in the condo setting, they're going to go to 45 and 45. So that's going to be, so you have 30-day courtesy late, 45, and so nobody's rushing to foreclose anybody here, guys. The law doesn't allow it.
Right.
Yeah, right. Very true. But it's really a shame that, once again, the folks who are not honoring their obligations get the windfall of the legislation, because now every other member has to pay for these added steps for the dingbats who aren't paying their assessments.
Right. And if my information is true, and I preface it by saying if my information is true, it's frustrating that there's a situation that occurred with one particular person up in Tallahassee and who has to be in a position of power, that they can then legislate the entire state to address their issue. I think that is troubling in this case in particular, when you take what the issue was and expand it into and it's got a dramatic impact. And Craig, without getting into it, you pointed out some real procedural issues that you as a management company and probably a lot of your fellow management companies are going to have complying with this without increasing costs to the associations, which is something else I argued. This piece of legislation is going to impact associations. And by that, I mean each owner, because they're going to be necessary additional administrative costs. And it's not right to pass it. It's the only community, the only party that it's properly passed on to is the association in this regard. And you can't pass it to the delinquent owner.
Yeah. The last time this happened, that a legislator had something happen to them and then we have legislation that affects the entire state, was the Woodside decision that led to the Woodside decision, really. Condominium leasing, right? We had a situation where there were a group of investors. These investors bought in a condominium association for the purpose of renting the units. The owners didn't want it. The owners passed an amendment to the declaration that said no leasing. These owners were upset. The new owners, the investor group, they sued. They lost. Florida Supreme Court says, hey, you're sophisticated investors. You knew they could change the rules and did. So what happens a year and a half later? Florida legislature puts that leasing restriction in 718-110, was it 13 or 14, that
13.
says the leasing can only be effective against those who voted in favor of it until title changes hands. So what happens is a legislator gets upset, they misuse their power. It's a gross misuse of power, if you ask me. Anyway.
Well, on that note, I prefer not to talk about politics as it just gets me more and more frustrated. So we are done. Thank you guys. Thank you for all of your insights as usual. Wonderful job. Appreciate your time. Our next episode is hosted by my partner on May 26th. We'll be back in early June. Any closing comments?
Just stay safe, stay well, stay smart, and see everybody next month.
And I appreciate everybody's attendance.
Yeah, we do too. Thank you, everybody. And we'll look forward to chatting with you again soon. Have a great
Thanks, Greg.
afternoon. Bye-bye.
Thanks,
Bye-bye.
Greg. Bye-bye, guys.